Holly, there's two kinds of homestead exemptions.
There are.
Tell listeners about them.
So there's the one that our callers are most familiar with. It's the homestead tax exemption you receive from the county that reduces your real estate tax. The second one is a more important one, I think, and that's the one through our Constitution that protects your homestead from judgments. And in the state of Florida, you get to protect 100% of your homestead against creditors. So if you get into a car accident, rack up a huge medical bill, they cannot come after your homestead property. It's 100% protected via the homestead protection in our Constitution here in Florida.
So these two homestead exemptions, they got the same exact name, homestead exemption, but there are two types of them. They are completely different, but they're called the same thing. So the one you just spoke about is given to us by our Florida Constitution, which states that here in the state of Florida, no creditor may take away the home of an individual or place a lien against it. Doctors, hospitals, credit cards, automobile accidents, you name it.
Correct.
If it's your home, it's protected.
It is.
And then the other one is given to us. It says that if it's your home that you live in and you've applied for homestead exemption, it's been granted, they'll knock $50,000 off the assessed value of your home every year, and that will save you about $750 a year in real estate taxes.
And that indeed is the savings that most callers are familiar with.
Yeah. Hey, by the way, there was an article in the paper yesterday or a few days ago about a Florida Supreme Court case that ruled in reference to the real estate tax homestead exemption. I put that article on Chrissy's desk, by the way, and maybe she'll hand it to you when she's done with it. But it said this, is that the Supreme Court ruled that there was a gentleman here in the state of Florida that he had a home. He lived there, clear enough, easy breezy. But he had rooms within that home that he was renting out to people.
Ah.
So the local county tax appraiser's office said, hey, man, this is you live there, but you're not using the whole thing as your homestead. You got these rental rooms in your home. Therefore, we're only going to give you an 85% homestead exemption. We're going to knock off 15% because you're renting out these rooms. That owner appealed it, filed a lawsuit. It was appealed to the district court. It was appealed all the way to the Florida Supreme Court, and the Florida Supreme Court upheld what the county tax appraiser's office and said, yeah, he's renting out a portion of this property. Therefore, he's not going to get a homestead exemption on it. 85% is what we're going to uphold.
Okay.
So that was kind of interesting. But the interesting thing about those facts is that the entire downstairs was for his living. The entire upstairs was 4 rental rooms. Some of them had their own kitchenettes. They had their own entry door. They had their own doorbell. So this was pretty clear.
It was,
that he was splitting his property up into where he was living and also at his homestead. So to me, the appraiser's office could have said, hey, man, I'm only going to give you 50%.
Right.
They were being pretty generous when they called it 85%. Mm-hmm. But the Supreme Court took that fact situation into account. Separate doorways in, separate floor, separate bathrooms, kitchenettes, etc. I mean, it just couldn't be more clear that this was like a rental portion of his property.
Okay.
So by the way, that's a pretty limited fact situation, but I don't think it'd be much different if you maybe had a garage apartment, possibly. I'm not sure if it applied to that or not.
I wonder because that's very popular in South Florida, where you'll have a property that then has the mother-in-law suite, which is detached and in the back.
Yeah. Holly, so let's go to the Florida constitutional homestead, okay?
Yes.
Florida Constitution says that if it's your home and you live there, it is protected from creditor claims. It's protected from bankruptcy. Mm-hmm. Okay. So many, many years ago, there was a very wealthy person that lived in Winter Park. He had a large, let's go back and say this. Under the Florida Constitution, if you live within the city limits, your home is protected up to 1 acre.
1 acre in city limits.
If you're out of the city, in the county, I think it's 140 acres.
40 acres. Yes.
140 acres?
140.
So
Or
a
160.
very wealthy, 160 acres, something like that.
Yep.
So a very wealthy individual in Winter Park has an estate on a lake in Winter Park. It's bigger than 1 acre.
Hmm.
So he files bankruptcy, claims homestead exemption, and under Florida Constitution, which says you can protect up to 1 acre if you live within the city limits. He's within the city limits. So he had a very smart bankruptcy attorney who drew a line around his home and then a small driveway out to the street and said, okay, here's my 1 acre where my house sits and a little bit of a strip to get out to the street.
Uh-huh.
That's what I'm protecting. And guess what? The bankruptcy court didn't go for it. So he lost that in bankruptcy, but why? Because Florida Constitution says if you're within the city limits, you're only protected up to 1 acre.
1 acre.
If you're over an acre, you don't get the same protection. So I remember that was a bit well known. Lawyers trying to stretch the limits, push the envelope.
Push the envelope.
And didn't work. Did not work.
Okay.